Hello, everyone, and welcome to the United States Patent and Trademark Office webinar series for experienced practitioners. My name is Marisa Terrell, and I am an attorney in the Trademarks Customer Outreach Office, and I'm pleased to serve as your host today. Now, as an experienced practitioner, you may represent a client who wants to protect a trademark in multiple countries. Wonderful. You are in the right place. Today, we will discuss the Madrid Protocol, a convenient way for trademark owners to file one streamlined application to register their trademark in up to 130 countries. And we'll be talking about that today. Now, before I introduce our experts, Kelly Cho and Debbie Lee, I'd like to share just a few announcements with you. This session is being recorded for your convenience, and captioning is available. Now, you can access the captioning feature by clicking on that little CC icon found on the bottom left. And you can also check your chat feed, and you'll also see a link there where you also can access your captioning. You'll have access to the recording in about 3 weeks or so by visiting our website, USPTO.gov. You'll notice that today's presentation features a number of terrific slides. Now, you should have received these slides via an email from Eventbrite after you registered for this event. But if you haven't received them, you're in luck. Throughout the presentation, our superior technician, Jay, will share a link to those slides, and you can find that in the chat window. And you can find a link in this window. All you have to do is just click on there. But you'll notice that those links in that chat thread are not live. Therefore, in order to access them, you'll have to copy them and paste them into your browser. And finally, these slides will also be emailed to you via Eventbrite today at 3:30 p.m. Eastern Standard Time. Now, at the conclusion of the slide presentation, time permitting, we're going to open up the discussion for questions. So please submit your questions via the Q&A window. How? You simply type your question in and hit enter. We're going to try our very best to answer as many questions as possible at the conclusion of the presentation. However, unlike some of our other presentations, we will not be replying in writing to your questions in the Q&A feed today. Finally, one last thing. Please remember that we're not able to provide legal advice. So keep that in mind as you're jotting in your questions. We've got a record number of attendees, so it's possible that we may not get to all the questions. Please bear with us. And finally, be aware that the chat thread for today is for announcements only. It's disabled during today's presentation. Now let's meet our experts. Our first expert is Kelly Cho. Now, Attorney Kelly Cho is an attorney advisor in the Office of the Deputy Commissioner for Trademark Examination Policy, where she serves as one of the Madrid Protocol liaison attorneys on the petition side. Now, before joining the petitions office, she worked in the Office of the Trademark Classification Policy and Practice as a senior attorney in Law Office 109. And prior to that, Attorney Cho served as a trademark examining attorney. We also have Attorney Debbie Lee. Attorney Lee is an attorney advisor with the U.S. Patent and Trademark Office, and she's been serving in that role for more than 18 years. She currently works in the Office of the Deputy Commissioner for Trademark Examination Policy, where she serves as one of the Madrid Protocol liaison attorneys on the policy side. Now, before joining the policy office, she was an attorney advisor in the Office of Policy and International Affairs, where she provided advice regarding trademarks and geographical indications across a variety of regions. Attorney Lee also served as a trademark examining attorney for 7 years. And now, it's my pleasure to turn the program over to Attorney Cho and Attorney Lee. Welcome.
Thank you. Thank you so much. The way we're working this presentation, I'm going to start this presentation off for us, and then I'm going to pass it over to Kelly Cho, and then I am going to pick it up at the very end, and then we'll wrap it up with a Q&A with both of us. So what we're covering today, we're going to do a very brief overview of the Madrid system. Then we're going to talk about filing and the review process of an international application, how to avoid getting a denial of certification on your international application, how to file a petition to the director if you need to do that, how to respond to a notice of irregularity on your international application from the International Bureau. And then we're going to cover a couple of important points to keep in mind after your international registration issues. Okay, so a couple of big picture points about the Madrid Protocol. It's a filing protocol treaty only. So the members, the contracting parties, the members of the Madrid system did not agree to harmonize their trademark laws. This is literally just about facilitating the filing of trademarks through the system. The goal is to provide a cost-effective and efficient method for obtaining protection in multiple countries. And one of the main features of this is that you file a single application with a single office. That's your office of origin. You're going to file and you're going to receive communications in one language. That's the working language of your office. For us, that's English. And you're going to pay the fees in one set. So that's a nice, convenient piece of it. Another feature is that you don't need to hire local counsel in all of your designated jurisdictions at the time that you're filing your international application. If that comes up, you will need to do that later. When the international registration issues, each contracting party that you designate in your international application is going to make the determination as to whether or not it will be protected in their jurisdiction. So you file for an international application that the International Bureau, if it meets certain requirements, will register as an international registration, and then the designations will be sent out to your jurisdictions that you designate in the international application. So a key feature of Madrid is that when a designated trademark office grants protection for your internationally filed trademark, that protection is the same as if you had filed the application directly with that office. So that's a key feature of the protocol. It also simplifies the subsequent management of the mark. We're going to talk about that at the end of the presentation, but I'm talking about things like, recording an assignment, if you need to update the name or address of the holder, filing renewals of the international registration, or designating additional jurisdictions. Those are pieces of maintenance and activities that you will do after the international registration issues. Another key feature of this is that Madrid is administered by the International Bureau. We refer to it as the IB throughout this presentation. And the IB is a sub-organization within the World Intellectual Property Organization, or WIPO. You will see references to WIPO and to the IB within this presentation. Currently, the Madrid system covers or gives you the opportunity to get protection in 114 different contracting parties. So those are intellectual property offices that cover 130 countries. And then what I'm going to talk about in the next couple of slides is just a big picture overview of the process of filing for an international application and then having your designation sent to, one of the jurisdictions that you name. So when you start to file into Madrid, you're going to start with a national trademark application or registration. It's referred to as the basic mark. That serves as a basis to file your international application. You will submit that international application with the Office of Origin, wherever you have that national trademark application or registration. And that Office of Origin will then review the international application to make sure that certain data in the international application matches the information in your basic application or registration. And if it does, it will certify it and then forward it to the International Bureau. The International Bureau will then conduct a formalities review. They're examining your international application. They are not doing a substantive examination. It is checking to make sure that certain data has been provided and that the data that you provide makes sense. So the dates are, lining up properly, that kind of thing. And then if they pass it to registration, they record it, they publish it in the WIPO Official Gazette, and then they will issue the international registration. Once this process has been completed, they will notify the holder that the registration is issued, but then they also notify all the offices of the designated contracting parties that you ticked off in your international application. So it's all little check boxes. So all the offices that you intend to designate, they will not be notified until the international registration issues. And then this is the point at which your trademark applications, I'm going to call them the baby trademarks that come off the international registration, they undergo the substantive examination in each of the designated parties. They will use their own national law and rules of practice to make a determination about whether or not the trademark application can be protected. So they have two options. They can automatically grant it protection. That's in PTO speak, that's a first action pub. So they're not issuing a refusal, or they can issue a refusal based on, any substantive issues or any procedural issues under national law and rules of practice. So a key piece of Madrid is when they issue that initial refusal in the PTO language, we call that the first action. That is sent to the International Bureau, not to the applicant. That goes to the International Bureau. It will be recorded by the International Bureau, and then they will send it to either the holder, or if the holder has an IB representative appointed, it will be sent to the IB representative. So it does not go directly to the applicant, that first refusal. Once each contracting party has conducted its examination and they've made a final determination as to the protection status, they will then follow up with the International Bureau by sending what's called a final disposition notice, which states the final status of protection in that jurisdiction. And so the International Bureau provides a mechanism. It's a website. It's kind of like our TSDR. And it's called Madrid Monitor, and you can go in and check the status of what countries have issued a final disposition or even a provisional refusal on your trademark. Some noteworthy items. An international application can be based on one or more applications or registrations, so long as they all cover the same mark and they are owned by the same party. So if you have multiple national applications or registrations because the applicant's business has expanded or whatnot, those can all be consolidated into one single international application filing. Fees. So the fees that we charge, we have initially when you file, we charge a very nominal fee to certify, to do that certification review. But then the applicant is also required to pay what we call the international fees. And those are the basic fee that's due to WIPO. Kelly's going to talk about those in a little bit, but keep in mind that the basic fee that the International Bureau charges is a little bit more if the mark is in color versus black and white. It's a little bit of an old-fashioned fee schedule, but they are looking to modernize. But for right now, the fees are a little different. And then at the time that you file, you also will be paying your designated contracting party fees. So those are the filing fees due to each of the countries that you designate. And as we said before, the scope of protection is going to be determined by the designated contracting party under their national law and their rules of practice. They do have a right to refuse registration, and they also have a right to invalidate a registration that's been issued. So similar to, under our law, you can file a cancellation against a registered mark for certain statutory grounds. That's what we mean by right of invalidation. Some other things to keep in mind. The Madrid system restricts the amount of time that each of the contracting parties have to issue the refusal. The idea is to keep everything moving. And so the parties, when they join the system, they can choose if they want that refusal period to be 12 months or 18 months. And then there's also an option to issue a refusal beyond 18 months if the refusal is rising out of an opposition. So the parties get to choose. Some, keep that in mind, some jurisdictions did opt for 12 months. If you've done some Madrid work with the PTO, you know that we have 18 months. Another key feature of Madrid is the 5-year dependency period on the basic mark. We're going to talk about this in a lot of detail at the very end. But what this means is that the international registration is tied to the protection status of the basic mark for 5 years from the issue date of the international registration. And that can have significant implications for you. The system, as a way of softening this effect, does offer up transformation so that if one of your trademarks, I'll call them the baby trademarks, in one of your designated offices is canceled due to a change or the death of the basic application or registration, you do have the option to transform your designation into a national filing. What will happen is it falls out of the international system, but at least the registrant or applicant in that jurisdiction will maintain some rights. You also have the possibility to file a subsequent designation, and that is a filing with the International Bureau that you submit when you want to designate additional parties. It can also be used, so I talk about here, geographic expansion. The business is doing great. We're going to throw in some additional countries. Great. That's one option. You can also redesignate after a provisional refusal. So that is an option. You might want to weigh the cost effectiveness of that depending on the grounds for the refusal. But it is available. There's nothing stopping you from doing that. And then another reason that people do a subsequent designation, you can redesignate a previously designated party with additional goods and services that you did not include. So that's another reason to do that. Expansion of trade. Some reminders. I'm going to go ahead and pull this out, all of these little items here for us. Okay, so key feature, the rights in the international registration may not exceed the rights in the basic mark. So I'm going to nuance this a little bit because this really goes back to when you file your international application. So I had said before, you start with your national trademark application or registration, and then you file your international application. And your data, your key pieces of data, the owner, the mark, the listing of goods and services, the nature of the mark, those form the basis to file that international application. So that mark that's in the international application has to match what's in your basic application, and it can't be something different. So the mark has to be the same. If you file through the USPTO, we do require that the description of the mark be the same. The listing of goods and services doesn't have to be the same, but what the listing of goods and services in the international application can't be broader than what's in your basic. So you can pick and choose out of your basic, but the international application cannot be broader in scope in terms of your listing of goods and services. If your national mark is a 3-dimensional mark like product configuration or product packaging, or if it's a certification mark or a collective mark or a sound mark, your international application must also be that same type of mark. If your basic mark is in color, has color claims, the color claim has to be the same in the international application. If your basic is a standard character mark, your international application has to be a standard character mark as well. So that's the key principle there. Another key principle, Madrid is administered at WIPO, at the World Intellectual Property Organization. The sub-agency that manages Madrid is the International Bureau. And I'm just going to talk a little bit about how they're organized because it impacts you as a customer. So they have 4 customer service teams in operations. They're not just customer service, they're just operational teams. So the great way that they organize this is that the teams specialize in certain regions, certain member states. So if you want help with a filing, or if we want help with a filing, we go to one team that is very familiar with the filings that come out of the United States, which is super nice. So they handle the processing of our applications. They process the decisions from national offices, requests regarding maintenance of rights, corrections, restrictions. And then, like I said, they do customer service for the users, for the public who are filing through the system. And they're very, very, very responsive. The International Bureau is extremely customer service oriented. So don't be shy about reaching out for assistance if you need it. These teams also provide outreach to the member states that they cover. I'm going to skim through these slides. You're going to see I'm going to skim through some of the slides as we go just for time. But the key piece from this slide really that I want you to take away is that the United States has been a member of Madrid since November of 2003, so just a little over 20 years. If you want to look up the legal history of this, we've got it in there for those of you that are super interested in the history of things. We've got information on the final rulemaking that we had to do. But really, the point on this slide that I wanted to point out to you is the USPTO is a top 3 filer, both as an office of origin and as a designated contracting party. So we do a lot of business with the International Bureau. And in terms of statistics, I've got them for the incoming, our 66As. Ever since we've joined the 66A incoming designations through the Madrid system, comprise roughly 8 to 10% of our total applications. So we're kind of hanging in there with that standard percentage over the last 20 years. I think we've kind of covered this a little bit, but I didn't skip over the slide because I just want you to see that I've got some legal sites in here. Madrid is a 2-way process. Today, we're talking about filing into the international system from the USPTO as an office of origin. That's the top part. We've got the relevant TMAP sections if you're looking for more information. But then we also have the incoming request for extension of protection. Those are the designations. I've been saying designations because it's shorter, but also called a request for extension of protection. And those are the TMEP sites for that. Those are our 66A applications. I'm going to talk a little bit about just some particularities of the USPTO implementation. We did adopt the 18-month refusal period. If we have not notified the International Bureau that we're refusing a 66A, a Madrid request for extension of protection, a Madrid designation within 18 months from the date we receive it, it's an automatic grant of protection. We have lost our right to raise grounds to refuse after that 18-month period. The other particular option that we went with when we implemented is we do require a declaration of intent to use. That should surprise none of our practitioners. When someone is designating the United States, they are going to include that declaration on the IB's MM18 form. It is not sent to the United States. We do not examine it. The International Bureau holds those forms, and they are made available upon request. So if you have a litigation interest in checking out the declaration of intent to use, you can contact the International Bureau to request a copy. We also chose to charge an individual fee. The system is set up so that the parties can charge a standard fee or a fee of their choosing, and that's what the individual fee is. We're doing that. And we also chose to incorporate the designations into our trademark filing system. So in other words, if you look in TSDR or you search through TESS for trademarks, you will also be searching for our incoming 66A applications and registrations. They're included. That is not always the case in every jurisdiction. That's just something we decided to do for transparency. And then we also established a separate unit, a business unit to process Madrid transactions called the Madrid Processing Unit. Just going to talk briefly about this because this is relevant to you from an Office of Origin perspective. The Madrid Processing Unit is not very big, actually. We have one supervisor, one administrative assistant who does a whole bunch of things that do not really fall under the standard definition of administrative assistant. She's great. We have one lead specialist, also great, and 6 specialists. So it's not big, but they do a lot of work. For your purposes, what you care about, they examine the international applications. They review responses to irregularity notices that you might receive and send for your international application. And then they send our ceasing of effect notices to the IB. We're going to talk about ceasing of effect notices at the very end. A couple of little resources I want to point out to you. We just did a major overhaul of our webpage for Madrid, and this is the link. I'm just going to do a really, really fast, I hope, little overview so that you can see what this looks like. I'm going to take you from the USPTO main page in case, you know, you want to start from here. If you, from our homepage, USPTO.gov, look under trademarks, and then down here under getting started is Madrid Protocol. So I'm showing this off because we reorganized the content so that if you are looking for information relevant to you as an outbound filer, so someone filing from us as Office of Origin, what we're talking about today, that is under the outbound applicants section. And if you are filing as a 66A applicant incoming, that's an inbound applicant section. The other features of this that I really love, over here on the left-hand side, you have a link to, this is to WIPO's Madrid Protocol main page. They have great information. I'm going to show you that in a second. Our T's I forms, when you want to file an international application, any of the Madrid forms are linked here. The relevant sections to the TMEP for Madrid are linked here. Also super helpful, WIPO fees and payment information, but more exciting, the WIPO fee calculator when you want to know how much it's going to cost you to designate a country or the total cost of your international filing. This is super, super, super helpful. Okay, and then I'm going to skip over here. This is the next slide, but I'm going to show you this. So this is the IB's. Well, this is not it. This is the customer service page. This is what happens when I go off-road. Hold on. Here we go. So this is the main Madrid website. I just wanted to show you, you can use the link. You can also get here by just doing, entering Madrid Protocol into any search engine, and it will, this page will come up first. I'm showing off this to you because there's certain information you can get from us that's relevant. So if it's relevant to the USPTO practice, it's going to be on our website. If it's relevant to Madrid in general, it's going to be on WIPO's website for the Madrid system. So I want you to see this. I'm just going to point out a couple of things that are going to be relevant to you. The e-Madrid system, I'm going to talk to you about filing maintenance documents on for your international registration at the end. That's going to be through this e-Madrid portal that they have. And then here's some juicy things for you to look at. So under legal resources, Madrid system members, the IB maintains, WIPO maintains a database of all of the Madrid members with their practice, their rules of practice and their laws. So you can click on this and you can find out if your target jurisdiction accepts, you know, configuration marks, for example. Different jurisdictions handle them differently. And again, your fee calculator is here, and that's super helpful. I'm going to pop down just a little bit more. If you go all the way to the bottom, here's your customer service information. I said earlier, they are very, very customer service oriented. You can get to their customer service team. That's where I was before. But really, the thing that is super helpful here is need assistance, send us your questions. You can call them, but when you click on this, it's going to pick up a form that you can submit questions. They will respond to you if you use this Contact Madrid form. It's a great way to get information and assistance from the International Bureau. So I just wanted you to see that. Kind of breeze through that rather quickly. Yeah. Okay, so hopefully, yeah, we're back. Okay. And then this is what I just showed you. So I did include it in the slide deck, but I just wanted you to see live. I wanted to show off some information. All right, so I'm going to turn this over to Kelly. She's going to talk about filing and review of the international application. Thanks, Kelly, and I'll move your slides.
Thank you, Debbie, and good afternoon, everyone. I will be covering the outgoing process, which is the filing of the international application at the USPTO as the Office of Origin. So that will cover the initial filing of the international application, certification review by MPU or the Madrid Processing Unit, and what to do if certification is denied. And again, in the interest of time, I just want to reiterate that some of the slides I might kind of breeze through or just highlight one or two key points. Okay. Filing options. So the international applications must be filed in English and electronically through our website. There are limited exceptions that we'll talk about in later slides, but generally they must be filed electronically. There are two separate fees that are due. The first is the certification fee, which is payable to the USPTO, and that's $100 per class if it's based on one basic application of registration, or $150 per class if it's based on two or more basic applications or registrations. Next slide. Okay, did we skip a slide? Sorry. I just want to cover that the second fee that is payable are the international application fees, and that is payable to WIPO. That's the basic fee, and you can see the breakdown of the fees. And there's also the fee that will be due to each of the designated contracting parties that are identified in your international application. Just quickly, that, as Debbie pointed out, there is that WIPO fee calculator, so you can calculate all the fees that are going to be due. But when you file through USPTO, those fees will be calculated automatically for you. So you don't have to necessarily go outside to search for that. Okay, next slide. So submitting the fees, just a couple of quick points that, again, when you're filing the international application, the certification fee is required, but that the international filing fees that are due to WIPO can be paid to the USPTO. And if you do choose to pay to the USPTO, we will forward that payment to WIPO, or you can pay those international fees separately, directly to WIPO. And just a couple of points about the credit card payment is $25,000 is a limit per day, and that these are sent via weekly. Next slide. Okay, so as stated earlier, the international applications must be filed electronically, and there are two electronic forms. It is the pre-populated form, and this can be used if your international application is based on one, a basic application or registration, and this would enable the international application to be populated, or all the data from your basic will be imported into your international application. Then the second form is the free text form, and you'd be using this if you have two or more basic applications or registrations, or if you decide to not use the pre-pop form because maybe there's some changes that need to be made in your international application. Next slide. So I mentioned that there are limited exceptions where paper applications may be accepted, but there are eligibility and filing requirements for this paper application, and that includes the IB's MM2 form, which is essentially the international application form created by the IB. That has to be submitted. U.S. Council rules would still apply. And as appropriate, it has to be submitted with a petition. We do have quite a bit of information on the mechanics of filing via paper or with a petition on our website if you wanted to get additional information on that. Okay, so the next slide really just shows what the TSI form looks like. And many of you who filed with the USPTO, you're familiar with our T system. TSI is a subset. TSI is basically T's International. And this enables online filing for Madrid Protocol forms. And this screenshot shows the pre-populated form, which is on the top, and on the bottom would be the free text form. So obviously when you are filing your international application, you would be using one or the other. Next slide. So what would be the advantage of using the pre-populated form? Well, again, you can only use the pre-populated form if the international application is based on only one U.S. basic application or registration. But if you're able to use a pre-pop form, it would basically pull all of the information from that basic application or registration and populate your newly created international application. So, and if there's no changes made, that application is what you want to submit, the USPTO will automatically certify that international application. There is no manual review. That gets certified and transmits to the IB, presumably that day. If changes are made to certain data fields, then the application will have to be reviewed by MPU, and MPU will then determine whether or not the international application can be certified. So next slide. So what are some of the disadvantages of using the pre-populated form? So the disadvantage is sort of the advantage as well, which is that because all of the data will pull exactly from what's in the basic into your international application, if there are any errors or mistakes in your basic application registration, that mistake or error will also pull into your international application. And those mistakes cannot be corrected or updated. So if there's a mistake in the spelling, in the mark, punctuation, maybe the color image or the color claim is not quite right, all of those discrepancies or mistakes will be present also in the international application. If there are some, and I guess we'll just move to the next slide. I'm going to talk a little bit about what you can do to fix any of those inconsistencies and discrepancies and in the later slides. But presume that you are using the pre-populated form and you make no changes. That means your international application will be automatically certified and transmitted to WIPO, to the IB. But if not, what is that certification process? MPU reviews the international application and compares each basic application or registration with the information in the international application. Then MPU will either certify and transmit that international application to WIPO, or if there are some discrepancies, MPU will deny certification and sends a denial letter to the applicant, basically identifying the reasons for the denial of certification. With the denial of certification is an automatic refund of any international fees that are paid to the USPTO. So if when you filed your international application, you filed both the certification fee and the international application fee, if you're denied certification, those international application fees will be refunded back to you. Next slide, please. So the next few slides are going to highlight some of the key elements for review of certification, and Debbie actually touched on most of these during her slides. And again, NPU will be reviewing certain information in the international application with what is in the basic application registration. And that includes ownership, the reproduction of the mark, whether there's a standard character claim, and whether the description of the mark is the same. Next slide. I think I kind of just talked about this already, so if we could just skip to the next slide. So another key element, and again, Debbie touched on this as well, is an indication if it's a special type of mark, like a three-dimensional mark, sound mark, collective mark. Next slide. Another key element is the identification of goods and services. And as Debbie mentioned earlier, the identification, the listing of the goods and services in the international application cannot be broader than what's contained in the basic application or registration. And this is where we talk about scope of the ID in the international application being within scope of what is in the basic application and registration. There's an issue of timing also that comes into play. For example, if the ID in the basic application and registration has been amended between the time of filing the international application and when NPU actually reviews for certification purposes, I mean, if the ID has changed, has been amended, the international application could be denied certification. So just be aware of the timing issue, that if you're intending to amend the listing of goods and services in the basic, that it still will be covering all the goods and services that are listed in the international. Next slide. And this basically just kind of talks about the timing issue. We're not going to spend too much time on limitations in the international application, other than to say that limitations are optional, they're voluntary, and this is where you may elect to list only specific or limited goods and services into your international application, or certain designated countries. You may want to maybe include all of the goods and services that are in your basic application registration, but for certain countries, maybe you want to delete certain classes, delete certain goods. That is what a limitation is. And currently the USPTO does not review limitations. Next slide. So I did mention that while the identification of goods and services is an element that is reviewed by NPU, classification is not. NPU does not certify classification as long as the goods and services in the international application is not broader than the listing of goods and services in the basic application of registration. Classification is not something that that NPU will review. They do not certify that. That is solely within the domain of the IB the IB determines whether or not the goods and services are properly classified based on the Nice agreement. So what is the international registration date? As long as the IB receives the international application within 2 months of the date of receipt by the USPTO, the international registration date is the same date of that receipt by the USPTO. And this also applies to international applications that have claims of priority. So this the next slide sort of shows an example, so that even if the international application was filed with the USPTO on the last day of the priority period, the USPTO has 2 months to certify and transmit that international application to the IB. So technically, if you filed your international application on that last day of priority, the US, let's say, certification process maybe takes a little while, and that international application does not transmit to the IB for about, let's say, a few days, a week. While technically it may seem that that priority claim, is no longer valid, as long as we get that within 2 months of your having filed it with the USPTO, the IB will honor that priority claim. Okay, moving on to the next section. This basically covers tips on how to avoid a denial of certification. Okay, so the first slide. What can an applicant do before filing the international application? The first would be to review the data in each basic application of registration to ensure accuracy, to fix any inaccuracies or inconsistencies. And please to go ahead and use the data or information from TSDR and not from other databases. We still have some legacy systems in place that may not be an exact match or may not have been updated quite yet. So please remember to use TSDR. Next slide. And if you find an error or inconsistency in your basic application or registration, what are your options? And so this will depend. Is the error or inconsistency in a pending application, or is it in a registration? If it's in an application, you can contact your examining attorney if the application has been assigned, or to file a voluntary amendment. If your international application is based on a registration, you can file a Section 7 to, update the registration or to fix some inconsistency. So the next slide, I'm gonna kind of combine with the next slide because it's sort of the same topic. So we'll just skip to the next slide. And this has to do with the ownership issue, which is probably one of the more common issues that we see during the certification phase. And as previously noted, ownership must be the same in the international application with each basic application or registration. And if there are any discrepancies in any of the basic application registrations, you may need to file an assignment with the USPTO's assignment recordation branch, but just note that not all mistakes are correctable. Next slide, thank you. So once you hit submit on your international application, then what? Hopefully you will receive a notice from MPU that your international application has been certified and transmitted to WIPO. Success. Unfortunately, you may also receive a denial of certification notice from MPU, and this letter will inform you that certification is being denied and highlight the reasons why the international application is being denied certification. The denial is final. There's no back and forth process to respond to MPU. Your only two options would be either to file a petition or to refile a new international application. And that's kind of what's in the next slide. So as I said, you can either file the international application, hopefully with the deficiencies or inconsistencies corrected, or you can file a petition to review the denial of certification. Why would you file one over the other? So if you needed to retain that original filing date, and generally this would come into play if you have a claim of priority, and so you need to have that particular filing date. Because let's say you filed the international application maybe on the last day. So there is no additional days for you to claim that priority. So if you needed to maintain that claim of priority, you would file that petition to director. And this is basically a request to the director to review the MPU's decision or to exercise supervisory authority to permit the applicant to correct a minor mistake on the international application. Because as I think I previously mentioned, the international application cannot be amended or modified or changed. It will be transmitted as filed to the IB. So if there's like I don't know, even like a small punctuation that you might want to remove, there's no mechanism for us to do that. So the only two options is, again, to refile or to file this petition. Next slide. So what is required in a petition? In order to file the petition, there are two petition forms that can be accessed via our website. So you would use the petition form. There is a petition fee. And depending on whether the inconsistency or the deficiency is in the basic application registration, or if the inconsistency deficiency is in the international application, you may have to provide us with an MM2. So if, let's say, the mistake, the deficiency was filed in the international application, we would require a corrected international application. And WIPO does require that we use their forms. So you would need to download the MM2, which is, again, the international application from WIPO. You would have to complete it, obviously, with the corrected information. And with filing the petition, submit this corrected international application, this MM2, with your petition. If, again, the mistake is in the basic application or registration, you would need to ensure that that correction or update is made, whether it's through Section 7, the assignment branch, or with the examining attorney. Make the correction in the basic application registration and simultaneously file the petition that the inconsistency deficiency has been corrected or is being corrected, so that we can go ahead and ensure that we can meet that 2-month window of getting that MM2 to WIPO. And while these petitions, because of that 2-month window, are expedited, we do ask that applicants file them as soon as possible. It's simply not enough to file a petition on the very last day of that 2-month window, because, again, the petition has to be reviewed. The records have to be updated, ensured that they are now consistent, the same. The petition would then have to be granted before we can send the international application to WIPO. So if you can file that petition as early as possible, even if you know that the Section 7 hasn't been acted on, or even if you haven't yet heard back from the examining attorney, go ahead and file that petition, and just to let us know in that petition that you've already taken these steps and that you're waiting for the correction to be updated. Okay. Next slide. So other considerations for an international application is simply that applications, pending applications or registrations that have been issued on the supplemental register can still be used as a basis for filing into the Madrid system. And additional information can be, so the MM2 form or the international application form does allow supplemental or voluntary information to be provided. And that includes statements like disclaimers and translations. And so while we as the Office of Origin, we don't certify these statements, they can be added, particularly if you are going to designate into a jurisdiction that may require disclaimer or translations. And so this would just kind of obviate on the back end. Next slide. So other considerations, and this briefly for subsequent designations, is simply to indicate that the international registration date is the same and it will expire on the same date when you have a subsequent designation. And so this kind of just gives an example, an illustrative example of that. We're not going to talk too much about this one. This is just simply that certain contracting parties have elected to only allow subsequent designations only if the international registration date is after that country's accession or joining into the Madrid Protocol. And these are just a couple of those, a few of those countries. Okay. So notices of irregularity. The section, the good news is that the USPTO has certified and transmitted your international application. The bad news is that the IB has issued something called a notice of irregularity due to one or more deficiencies that they found during their review of the international application. So the IB may issue one or more if there are deficiencies, which can be issued for, these are probably the most common issues, is fees, classification, identification of goods and services, and there may also be some advisories, which is maybe, for example, if there's a claimant priority and they're telling you that there is no effect because maybe the international application was not timely filed. Next slide. So the notice of irregularity can be issued for deficiencies that must be remedied by the applicant or by the USPTO as the Office of Origin. The first type of irregularity can only be remedied by the USPTO, and this might be an omission of a drawing or a USPTO signature. The second type of an irregularity can be remedied by the applicant directly with IB, and that's normally just fees. And the third type of irregularity must be remedied by the applicant through the USPTO, at which point the USPTO would then forward to the IB. And this is the most common, of course, is the listing of goods and services. And this is where, the ID is too vague for purpose of identification, for classification, and that's under Rule 13 under the regulations, or classification, that the IB determines that certain goods or services are misclassified and should be classified in a different class. And that's a Rule 12 irregularity. Next slide. So responding to a notice of irregularity. Generally, the IB gives an applicant 3 months to respond. The USPTO does strongly urge the applicant to file their response as soon as possible, particularly if we're dealing with an identification issue. Keep in mind that any proposed amendment to the identification of goods and services must be reviewed by MPU, and it could potentially require further modification from the applicant. So we would need a little, having some time to be able to have a little bit of analysis and to figure out what the best way to comport with USPTO practice as well as with the IB's particular requirements would be ideal. Please note that the response must be filed and received by the USPTO before that 3-month deadline. If we receive it after that 3-month deadline, we will not process that response. And if you could please wait until that notice of irregularity appears as a transaction in TSDR before filing your response. It is possible that when an irregularity issues that our records have not yet updated to reflect the issuance of that irregularity, and perhaps you've already received it. And so if you've received it and you want to quickly respond, if we have not yet updated our records, our system won't allow you to file that response. So if that happens, just give it a day or two to let that notice of irregularity update in our records. The next slide shows what the TSI response form would look like when you're responding to the IB's notice of irregularity. And so some practice tips for responding to a notice of irregularity. Please use caution when accepting any amendment to the ID from the IB. The IB, as Debbie mentioned, is very customer conscious. They want applicants to be able to navigate through the system. So when they get these international applications where the ID is, for whatever reason, vague, insufficient for classification, they may provide a suggested amendment to the goods and services. You do not have to accept that suggestion, particularly if that suggestion exceeds the scope of what is in the ID in your basic application or registration. It's not uncommon for applicants to get this suggestion from the IB and immediately accept it, thinking that it's a must. It's not a must, it's a suggestion. Just keep in mind, again, that when you are amending the goods and services, that it stays with it, that it's not broader than what you have in your basic. Also use caution when reclassifying goods and services, because again, the IB may suggest that these particular goods and services should be reclassified in this class. And while yes, the IB controls classification of goods and services, it could be that the IB is suggesting reclassification because the specificity of the ID is not clear to them. So just be aware of keeping the ID itself within scope of the basic and keep the classes the same as what is in the basic with the international application or registration. You will lose any class that is in the international registration, which you do not have in the basic application. And this normally comes to pass when we issue ceasing of effects, which Debbie will cover later, but just keep in mind amendments, reclassification, make sure it's within scope and it's consistent with what you have in the basic. And in the past, we would ask that, the applicant wait to file international applications until after your basic application has been reviewed, or at least that you've, received an office action from an examining attorney. But realize with priority claims that sometimes this is not possible. But if it is possible, to please go ahead and do that. And I will try to speed through the last couple of slides. They're all kind of interrelated. Just want to point out that in responding to a notice of irregularity, timing, scope, and what happens when you don't respond. So timing. The listing of the goods and services, if you're going to amend it in the response, and this is for the international application, when you file that response, responding to that irregularity to the IB, NPU is going to review that newly amended ID with what is in the basic list of goods and services in your basic application and registration at the time that you submit the response. So if you have either filed the goods and services in the basic after the international application was filed, the goods and services in the response has to be consistent with that amended goods and services in the basic. It's kind of confusing, but just keep in mind that whenever you amend the ID in the basic, in the international application, it's got to be consistent at the time that NPU reviews either the international application at the time of certification, or in this case, at the time you're filing your response to an irregularity. And this is the next slide, again, just talks about the scope, which again is about do not exceed the scope of what is in the current listing of your goods and services. And the last slide is response to a notice of irregularity. What happens if you don't respond? If it's a fee issue, the IB will abandon. If it's a ID or classification issue, it depends. If class was provided and it was just an issue of vagueness, the IB will generally just sort of insert that language, but not change the ID. But if class was not provided and there's a fee issue, because maybe they're suggesting that an additional class be added, that could result in either reclassification or the deletion of the unacceptable terms. And that is the end of my portion of the presentation. This last slide, unfortunately, is sort of a repeat, so I will now turn it over to Debbie.
Thank you, Kelly. Okay, so as I promised, we're going to talk about some issues that come up after your international registration issues. Let me get myself squared away here. I apologize. I'm the one that was advancing the slides, and I clearly need to work on my timing, so I'm sorry to Kelly and to all of you. Also, I'm looking at the timing. It's about almost 10 after 3. I want to make sure we have time for questions. So I'm going to do a lot of summarizing of the remaining slides so that we have time for questions. And so don't worry, this is what we're going to talk about. Dependency and ceasings of effect, maintaining your international registration, which I really mean renewing your international registration, and making changes to your international registration. Okay, so we talked about this a little bit at the beginning, and Kelly touched on it too. A core feature of Madrid is the idea that the international registration and all of the baby trademarks, so all of your designations, are dependent on the scope of protection of the basic mark for 5 years from the international registration date. It doesn't matter if the designations were submitted in the international application or were submitted in a subsequent designation. Dependency is always tied to the date of the international registration. So if the international registration is, if the basic application or registration is canceled or abandoned, then the international registration will be terminated, and all of the designations associated with that international registration will also be terminated. If the listing of goods and services in the basic, it's going to be a registration, basic registration, are narrowed down, restricted, then we will send a notice to the IB letting them know that the status of protection of the basic has been restricted in scope, We will send them what remains protected in the basic mark, and then that will be translated into the international registration. And then the International Bureau will notify all of the designated parties of the change to the listing of goods and services in the international registration. And then in every single designation, the scope of those designations will be brought to within the new scope of the international registration. And so to summarize some of these slides, a ceasing of effect, it's actually the full official title of this notice is called a ceasing of effect of the basic mark. And that is a notice that we send when there's been a change to the basic mark that needs to be notified. So for the USPTO, if you filed your international application based on a pending trademark application, our IT system will automatically route a ceasing of effect for review to the Madrid processing unit when your basic mark registers. And if the listing of goods and services in your basic application has changed between the time you filed the international application and when your basic mark registers, if it's been narrowed, we're going to send a ceasing notice to the International Bureau. It actually happens about three months after your basic mark registers to update the listing of goods and services in the international registration. And again, if that basic application or registration dies, if the application abandons, if the basic registration is canceled within the 5-year dependency period, we will send a total ceasing of effect notice to the International Bureau. Your international registration will be terminated, and all of the baby trademarks, all of those designations will be terminated as well. So that is what I just summarized in these slides. That is core principle number 1. Talked about this. Oh, let me talk about the end of the 5 years. So when that 5-year dependency period ends, that relationship between the international registration and the basic mark ends. The only exception to this is there is a provision under the treaty and the Madrid regulations that if a proceeding against a basic mark commences within that 5-year dependency period and it is ongoing beyond it, we send a notice to the IB to let them know the proceeding is ongoing. And then when that proceeding terminates, we notify the IB of the outcome. If it's no change, we say there's no change. If the basic mark has been restricted, if the ID has been narrowed down, we update it. So that's the exception, I guess, to this 5-year absolute freedom rule, is that if the proceeding begins within the 5-year dependency period and it wraps up afterwards, we would notify the IB if there was a change or if there was no change. Okay, some other key pieces, because we do get questions about this. Ceasing of effect notices are only sent to notify changes to a restriction. We'll say a restriction to the listing of goods and services in the basic. So the ID's been narrowed down, or the basic mark no longer has protection. So we have no mechanism for sending any changes to the drawing, any changes to mark description, translation, owner information, or addresses. Those are not sent by us to the IB. You can't change the drawing. You can't change the mark description. You can't change the translation. And changes to owner and address we'll talk about at the last little part of this presentation. So again, ceasing's just talking about the ID or the final status of protection. It's dead. If it's dead, we send a notice. If the ID's been narrowed, we send a notice. And I talked about this. And we did talk about this. Negative consequences to the international registration may happen due to changes in the basic record during prosecution or after registration. I'm going to give you a couple of examples about that first. Kelly touched on this too in the past, and we still do advise our applicants to wait and to file your international application until you get the first office action. This is a problem if you want to claim priority, because as you know, from what Kelly just told you, if you want to claim priority in your international application, the international application has to be filed within 6 months of the filing date of your basic application. But our current pendency is 8.2 months, so you might not be able to wait that long. If you're in that boat, we really strongly encourage you to, you know, vet the basic mark before you file your international application, and try to determine whether or not it's going to be registered. And we also really recommend that you do your best to bring that identification of goods and services in your basic as close to perfect as you can get it. We know that's not always possible, but that will really help you. So some examples when we might see different inconsistent protection. So for those of you that have practiced before the PTO as, you know, national filings, you know that we allow the mark to be amended when that amendment is non-material. So for example, you can file that national application for right-on, and we will let you amend it to remove the dash. It's non-material under our practice most of the time. I'm not going to say all the time. Most of the time it would be non-material. If you file your international application with the mark as right-on, we have no way of correcting or changing the mark in the international after that international application is filed. It's going to be right-on forever. There's no way to remove that hyphen. Okay, the other thing we're going to talk about is this class change issue. I really want to touch on this because it doesn't happen all the time, but when it does happen, it can be severe for the applicant or the holder. Okay, so if let's say the applicant files the basic mark for headgear in class 25, and then they file their international application for headgear in class 25. Through prosecution, we're going to issue a requirement and say headgear is too broad, tell us what you mean. And we will give you the option to add motorcycle helmets in class 9. That's within scope of headgear under USPTO practice. But keep in mind that when we send a ceasing notice to the International Bureau, which will happen when your basic mark registers, we will look and say, oh, that listing of goods and services has been restricted. We cannot send them anything that says motorcycle helmets in class 9. If class 9 does not exist in the international registration, you will lose the motorcycle helmets in your international registration. So keep that in mind. And I think Kelly talked about this. This primarily comes up, or we see it a lot, when the International Bureau is offering suggestions to the applicant to cure an irregularity, especially when the wording is too vague for the International Bureau to determine classification. They will offer suggestions. They are trying to be helpful, but you ultimately are the one that knows what will be the final, or at least an idea of what is going to be the final listing of goods and services in the basic mark. And you want to make sure that when you respond to an irregularity, you don't just adopt a suggestion. Keep in mind that the ceasing of effect is going to come down the road, and you're going to want to make sure that what is in the international registration is covered by the basic mark when that finally reaches disposition, because a ceasing of effect will issue and you could lose classes or the entire international registration, depending. Now that I've scared you, let's talk about maintaining your international registration. We get a lot of questions about renewal, so I'm just going to give you a really brief tutorial in renewals. So your renewal is, well, first of all, your international registration is valid for 10 years from the date of the international registration. All renewals are filed with the International Bureau. And when you file your renewal, you will tick off which countries you also want to maintain. You want to renew in those countries. So that renewal is not tied to the date that the designation registers in whatever jurisdiction. It's always tied to the registration date of the international registration. So keep that in mind if you're doing subsequent designations, because it's still going to be tied to the international registration. If you file a subsequent designation 3 months before the IR needs to be renewed, you're going to have to pay the full renewal fee in that jurisdiction in 3 months. So just keep that in mind. Renewals are filed, basically all of your filings with just a couple of exceptions are going to be filed using the eMadrid portal on the WIPO's website. And I showed you that when I was showing you the website. So just keep that in mind. We can't accept them. This is a feature, not a bug of the treaty, that it's all centrally managed. If you fail to renew, the international registration will be canceled. And you know now what happens when the IR is canceled, all the designations, all the baby trademarks are canceled with it. So keep that in mind. All right. Let me say, is there something else I need to tell you? Yes, another question we get a lot is, will you get reminders? The International Bureau does send reminders to it will either be to the IB representative's email address if one has been appointed, or it will be the email address of the holder that was provided to the IB. They send them 6 months before the renewal is due. So that's how the reminders are sent. Okay, changes to the international registration. All the changes, with just tiny few exceptions, are going to go through the eMadrid portal. So I'm talking about assignments. I'm talking about non-assignment changes to the holder information. You also have a couple of options to restrict the listing of goods and services at the designation level. So in one or more particular countries or jurisdictions, that's a limitation. If you want to renounce your designation, that's a renunciation form. That's as to the contracting party, as to that jurisdiction. And then the word that scares me is cancellation of the international registration. So in the International Bureau speak, the holder can file a cancellation of the international registration, which is just like a voluntary withdrawal, I guess, of the international registration. But you can also file a partial cancellation, which deletes goods and services from the international registration. And again, if you make a change to the international registration, it's going to go to all the designated parties. So if you delete goods and services from the IR, that will be notified to all the designated parties, and the scope of the IDs in those jurisdictions will be brought to within the scope of the new ID in your international registration. Talked about ePortal just a little bit more. A little note, the IB does not require and will not accept evidence supporting changes of ownership. It's just a form that you file. When you submit the form, I'm just going to keep going here because here we go. When you submit the form to the International Bureau, you will need to have the assignee is the one that submits the form, and they will need the signature of the assignor on the form. In the rare exception that you cannot get the assignor's signature to request recordation of the assignment, you can file that change of ownership through the USPTO. So this is governed by our rule 7.23, so 37 CFR section 7.23. It's only available if the assignor no longer exists, or if the assignee, after making a good faith attempt, cannot get the assignor's signature. And it's also only available if the assignee meets those Madrid Protocol / Paris Convention entitlement criteria. You're a citizen, you're domiciled in the United States, or you have a bona fide industrial commercial establishment in the United States, you can file. And so this would pertain to a U.S. designation or an Office of Origin filing, as long as you have those minimum establishment criteria. And the way you do this is very rare, by the way, but the way you would do this is you have to use the IB's official MM5 form and attach it to a petition to the director for an international application or registration. And our petition attorneys will review it and then make sure that it's transmitted to the International Bureau. Okay, lastly, but not leastly for sure, where to find help. Assignment recordations. This is only for national filings. Will you need to talk to the assignments recordation branch? So if you've got assignment questions for an international registration, they would need to go to the International Bureau. So keep that in mind. The Madrid Processing Unit, very knowledgeable, very helpful. If you have questions about a particular communication you've received for your Office of Origin filing, please contact them. Email's great because they can forward the question if it's something they can't cover. If you have technical difficulties with the TEAS forms, TEAS-I forms, we have the TEAS mailbox, and that if you are having trouble, you just need help filling out the form, we have the Trademark Assistance Center. They're also a good first point of contact if you're not sure who to talk to, because they can route it to the appropriate personnel. So with that, Kelly, I don't know if you have anything else you want to talk about. If not, then we can turn ourselves to questions.
Okay, thank you so much, ladies. This was fantastic. Attorney Cho and Attorney Lee, such a wonderfully informative presentation. So much so that, look, we are we are running at the end of our time, but we want to be sure that we can open it up for some questions. We know that folks might have to drop off. We want to thank you for all of the information. We want to thank everyone who took the time out of their schedule to join us today. And we also want to take a minute to apologize to any of our guests who experienced any technical difficulty accessing today's presentation. It turns out that Eventbrite turned off our event page this morning, and this resulted in many of our friends being unable to access the link, the WebEx link today. You'll be happy to know that we're in the process of transitioning to a different system, but unfortunately that changeover is not complete just yet. Good news is that today's session is recorded, and the recording should be available in a few weeks or so. Once it's ready, you can find it on our website. You want to go to USPTO.gov, and you can go in and type in trademark webinar series, and you'll be able to find us. Let's see. Let's go ahead and jump into some questions now. We're going to start with one that was emailed to us. This is from Lauren. It's a two-part question. She wants to know, what's the preferred way to add an applicant's email address in the U.S. Patent and Trademark Office so it matches the account in WIPO? That's going to be, who wants to take that one? Debbie?
That one's going to be me. Yeah.
Okay, fantastic.
Because we had a little email exchange because I wanted to get a little bit more information. So, okay, a little background. I'm going to be really brief because I want to make time for other questions. The international application form only contains fields to collect data that the IB by regulation will take for an international application. So we can't add anything to that form that isn't going to the International Bureau in accordance with the international regulations, with the Madrid regulations. So the regulations provide for the email address of the applicant and the email address of the IB representative, if there is one. There is no provision to add a secondary email address, so there is no way to do that. I did have a suggestion that this person contact the International Bureau and suggest that this be added as an option. They are very open to suggestions, so I do encourage you to reach out to them. Yeah, that's my best advice for that.
Okay, I appreciate that. That's good information. We're going to drop on down to Liz. This is a question that came in through our feed today. She's asking, do you need a special certification or a licensure to be an IB attorney, an International Bureau attorney? Kelly, do you want to take that one?
I'm sorry, this is for the International Bureau to be a representative?
Yes. Do you know, she's wondering about if you need some special certification or a licensure to be an IB attorney. It's an interesting question. We might not even know that on that
I'm not
side.
sure.
Right. Okay.
I can answer that one.
Okay.
Sorry, I was not going to take over the whole thing. So
All right.
the requirements for an IB representative are not set forth in the international regulations, in the Madrid regulations under the Madrid Protocol. So you don't have to be an attorney to be an IB representative. So keep that in mind.
Okay. All right. I'm looking at the time. How about this question? I'll read the question first, and then I'm going to look at you ladies to see who's ready to jump in and answer it. Okay. This is from Jared for a subsequent designation. Okay. Is that designation still dependent on the basic application for 5 years after that subsequent designation, or just 5 years after the initial application? And let me know if you want me to repeat that. Who wants to take it? And I can repeat it again. Is that you, Debbie, looking at me with the eyes of someone who wants the answer?
I want, because I know Kelly can answer this too.
Okay, Kelly, you want to take this one?
Well, if we're talking about the dependency, it's 5 years from the registration, the international registration issuance. So it's not necessarily the initial application, it's just 5 years from when the international registration issues.
Okay. Okay, Jared, I hope that that was sufficient for you, but certainly feel free to send a follow-up and we'll try to check it in that Q&A, okay? We have a question from Barbara, still talking about this subsequent designation. When a subsequent designation is filed after the renewal was already paid for in the base international registration. Let me start again. When a subsequent designation is filed after the renewal was already paid for in the base international registration, does it then start with the next renewal deadline? Okay. I'm looking at faces. Debbie, you want to take this one because Kelly just answered the one before?
I have no problem with that. So when you
Okay.
file a subsequent designation, you have the option to determine when it will take effect. In this case, you're filing it after the renewal has already taken effect. So you've already paid the renewal up to speed, so you're ready to go. I'm assuming this is a new designation, so you're filing to a new country. And so you have already renewed the international registration. When you pay your filing fees for the subsequent designation, you're squared away. So you're renewing the international registration, and at that time, you're going to renew for all your existing designations. So if you file a subsequent designation thereafter, your international registration is good for another 10-year period. You can file all the designations you want to, and those initial filing fees will be sufficient.
Okay.
So that's confusing, but just remember the IR, the international registration is at the center of everything.
Okay. Kelly, did you want to add anything to that?
No.
Okay.
I
All right.
think Debbie answered that pretty well.
Okay, fantastic. Okay. Here's another one. Kelly, this is from Kelly. This question is from Kelly, and it's relating to an inbound application, okay? She's asking if she enters herself as the attorney of record for a Section 66 application soon after filing, where the U.S. was designated in a WIPO application, will she be copied on an initial office action if it's issued? Now, what do you think?
Well, for the incoming applications, when an examiner issues that first provisional refusal, by treaty, it would be sent to the IB. Yeah, so it would only be sent to the IB.
Okay. That's what I was thinking. Okay, thank you. All right. It's okay. We're going to take a few more just because we're over our time and we know that folks have busy schedules. But if you need to drop off, feel free to do so. Remember, we are recording this session for your convenience. All right. A question from Jody. Is there any way that you can tell us each country that will require a declaration of use after registration? Okay, Debbie. Yes, thank you.
Okay, my answer is no, I can't, but I know where you can find the information.
Wonderful.
So I'm still sharing my screen. I am on WIPO's website for Madrid. And what we're going to do is scroll up because I'm at the bottom of the screen again. Oh no, I'm on the contact page. Bear with me here. I'm going to go back. Okay, this is the main screen. Okay. what we're looking for is information about particular member states. So Madrid, the International Bureau maintains a database of all the contracting parties with all their rules. So if you go down to the legal resources, this is where all the gold is, honestly, this middle part right here. Go to the Madrid System members, and then you can get the list of members, and then under procedures, you can learn more about members' procedures, and this is the Madrid Member Profiles database. So if you want to know who is going to require post-registration declarations, you're going to search all the members, and oops, I have to let go do next. You can see I use this not very frequently, but it is here. So you can then pick and choose what it is you want to know about. And then it will actually display that information on a country by country basis. So all of the member states maintain this information. So it's as good as it's going to get, basically.
Okay, Debbie, thanks for showing us those websites, those web pages. It makes navigating through our web pages and the whiteboard pages so much easier. So we appreciate that. We're going to go ahead and get ready to conclude our presentation. Special thanks to Attorney Kelly Cho and Attorney Debbie Lee for leading our discussion today. I also want to thank my manager, Jason Lott. He is in the background helping us sort through all these attendee queries and that were submitted today. As you might know, Jason serves as the managing attorney for Trademark's customer outreach. I also want to draw your attention back to a few reminders. Around 3:30 p.m. Eastern Time today, you're going to receive an email from Eventbrite, fingers crossed, right, that contains the following. You're going to get a link to our survey. It should take you 3 to 4 minutes to complete. We always want to hear from you, feedback on what's working and what's not. You'll find, again, a link to our presentation slides, but you can also access them right now in our chat window. We're going to post a recording of this webinar on USPTO.gov and on YouTube in about 3 weeks or so. And my name is Marisa Terrell. I want to thank you for joining us today. Visit our webpage for information on our next webinar. That's USPTO.gov. Type in events in that search bar and you'll find us. Thanks so much.